So welcome everybody to this seminar on differentiation Group 1 and Group 2 refugees, the law and practice tips. Just to let you all know that this webinar is being recorded. Obviously we can't see you, so hopefully you're okay with that, but obviously do leave if you're not. We ask you to please keep your cameras off and keep muted. If you do have questions, please pop them in the Q&A box and we'll try to make sure we've got time to answer some of those at the end of the webinar. My name's Alison Pickup. I am an associate tenant at Doughty Street Chambers and I'm also the director of Asylum Aid. I'm joined today for today's webinar by my colleagues from Doughty Street, Laura Dubinsky, KC, and Michelle Knorr, who I'm sure don't need any introduction to you all, are very well known and brilliant public law barristers specialising in refugee law. The way that today's webinar is going to go is that I'm going to start with a very basic overview of the statutory provisions, the policy and the immigration rules. Then Laura is going to look a bit more closely at Article 31 of the Refugee Convention and how that interrelates with these provisions and its correct interpretation and some of the battle lines that might need to be considered in relation to these cases. And then Michelle is going to spend some time looking more practically at how you can ensure that you respond effectively to the opportunity to rebut a Group 2 decision later on. And then I'm hoping we'll have 20 minutes or so for questions at the end of the webinar as well. So on that basis, without further ado, I shall attempt to share my screen and start the presentation. Can you see that? The slides, Michelle, can you let me know?
Yes, I can see it perfectly.
Perfect, great, thanks very much. So I said I'm going to look at the statutory framework and policy, bit of the policy and immigration rules. So the starting point for today's webinar is Section 12 of the Nationality and Borders Act 2022. The other thing I should have said before we started is that we are not going to go into any detail or look at all the new bill. This is very much about the 2022 Act. How long these provisions will have any impact obviously will be depend on what happens with the new bill, but we're looking at 2022 now, not at 2023. So the first bit to look at is Section 12 of the Act, which defines the concept of Group 1 and Group 2 refugees. So essentially a Group 1 refugee is a refugee who has come to the United Kingdom directly from the country or territory where their life or freedom was threatened and presented themselves without delay to the authorities. Additionally, if they enter or are present in the UK unlawfully, they also have to show good cause for their unlawful entry or presence. So a Group 1 refugee is somebody who can satisfy all of those requirements. A Group 2 refugee is anybody else who's recognised as a refugee in the UK. So in order to understand the concepts of coming directly and delay, we need to look at Section 37 of the 2022 Act, which defines these concepts for the purposes of Section 12, but also more generally. The key points here are in terms of whether the refugee came to the UK directly, did they stop in another country outside the United Kingdom, unless they can show that they could not reasonably be expected to have sought protection under the Refugee Convention in that country. That's Section 37.1. Section 37.2 deals with the question of delay. And so the question there is whether the person made a claim for asylum as soon as reasonably practicable after their arrival in the United Kingdom. In the case of surplus refugees, the question is whether they made a claim for asylum if they were here lawfully when they became surplus refugees at a time when their presence in the United Kingdom was still lawful. So if you're here on a student visa, things change in your country of origin and you need to claim asylum, as long as you do so before your student visa expires, you're treated as having claimed without delay. But if you were here unlawfully, you overstayed or made an illegal entrance at the time that you become a refugee, then again, the requirement is that the refugee made that claim as soon as reasonably practicable after they became aware of their need for protection under the convention. So that's the very basic statutory framework, sections 12 and 37 of the Act. The Home Office has published detailed guidance on these provisions, which is in the Assessing Credibility and Refugee Status after 28th of June 2022 guidance, which you can find on the Home Office website. And I'm going to look at some of the stuff in that guidance in a little bit of detail, and Michelle might go into some more detail, because actually it's quite helpful in some respects in terms of the factors which the Home Office acknowledges need to be taken into account, and also in terms of some of the examples that are given. I won't necessarily have time to go to all those examples, but I would really recommend looking at the case studies and examples in the guidance, because some of them are perhaps surprisingly helpful, some of them less so. But you might find something in there that helps a client. So if the first part is looking at coming directly, so that first part of the test, did the claimant come directly or did they stop in another third country on the way to the UK? So the guidance identifies a number of factors to be considered, and those are set out here. So how much time did they spend in the third country? Did they have access to an effective asylum system? And the guidance talks about it being accessible and effective, and refers even to the availability of legal aid and rights of appeal. The practical ability of the person to access the asylum system, looking at their freedom, their access to information, their location in relation to where claims need to be registered, and then mitigating factors such as personal circumstances and vulnerabilities. That's coming directly, the guidance, and that's something that certainly Laura will be looking at in more detail in relation to Article 31. The second part of the test is, did they, having got to the UK, claim asylum without delay? And here the guidance indicates that relevant factors include how they entered the UK, whether they had access to legal advice, whether there were immigration officials present on arrival, on any mental or physical health problems that might impact on their ability to navigate the system, again, the distance to the asylum intake unit, and their access to transport, including availability and affordability. But worth noting that the guidance does, perhaps unsurprisingly, suggest that if you claim asylum after being arrested or after your removal directions have been served, that won't usually satisfy the test of claiming without delay, unless it was reasonable for the person not to have done so. So again, there's an exception there. The guidance on without delay goes on to list other factors which could explain delay. And again, I think these are quite helpful to look at. These include symptoms of trauma, which is good to see that recognised, that trauma may prevent someone coming forward. Language problems, erroneous advice provided by smugglers, a lack of accurate information or difficulty understanding information provided, including lack of access to or otherwise limited legal advice. This one seems to me to be particularly important in the current context of real difficulty in accessing legal advice. And so explaining, if you've got a client, how they were unable to understand what was required of them or without getting access to legal advice, and how hard that was. Also, reliance on erroneous advice from persons offering immigration advice or from relatives or friends in the community. And then importantly, feelings of insecurity, mistrust or fear, including that resulting from the experience of being a refugee or from previous experience with authorities. So a good recognition there that the facts that have led your client to seek refuge in the first place may be the very reason why they are reluctant to approach authorities. Again, fear of detention, potentially based on past experience of this, or in the current context, perhaps on the rhetoric from the government about detaining all asylum seekers. Fear of border crossings, points of entry as unsafe or inappropriate places to make a claim. On refugees sur place, I've put this passage, again, this comes from the same guidance here in full, because it seemed to me to be very helpful for sur place refugees. So the situation in refugees' country of origin or their personal situation may change slowly over time, such that it will often be difficult to identify exactly when a person first had a need for protection under the Refugee Convention or when they became aware of it. In some situations, a refugee may also reasonably defer their claim, believing the situation in their country will improve, and claim only when they consider the situation continues to deteriorate without a sign of improvement and the risk to them therefore endures. Should not generally hold a claimant's desire to return to their country of origin against them in this consideration, but still consider whether the length of delay is proportionate to the desire to return to the country of origin. This one particularly resonated for me in the context of some of our clients from Ukraine who didn't want to go ahead and claim asylum straight away. And I'm sure there are other situations where that will be applicable. The guidance goes on to more factors to consider in the context of looking at whether the person claimed without delay: personal factors, mental capacity, illness, physical capacity, age, trafficking, sexual and gender-based violence, and LGBT plus claimants in particular. So that's claiming without delay. So we've done stopping en route, claiming without delay, and then for those who are here unlawfully or enter unlawfully, which as we know will be the majority, then the question is whether they had a good cause for their unlawful entry or presence. Helpfully, the guidance recognises that in most cases, this test will be met by refugees who have passed the first two first two tests. The two examples given in the guidance of where this test might not be is the case of overstayers who perhaps could or should reasonably have claimed earlier than they did and can't justify a long period of overstaying, or refugees who could have availed themselves of a safe and legal route, so that will be rare. Okay, so that's the test for whether someone is a Group 1 or a Group 2 refugee. Remember that you have to have satisfied all three of those tests to have come directly, claimed without delay, and have good cause for your unlawful entry or presence in order to be a Group 1 refugee. If you're not a Group 1 refugee, then you're going to be a Group 2 refugee. And Section 12 goes on to provide that the Home Office can treat Group 1 and Group 2 refugees differently in 4 respects. First of all, the duration of their leave. Second of all, the requirements they have to meet in order to be given indefinite leave to remain. Thirdly, whether there is a no recourse to public funds condition. And fourthly, whether their family can be given leave to enter or remain. So what do the immigration rules say about these things? First of all, the paragraph 339QA makes clear that Group 1 and Group 2 refugees may be granted different periods of permission to stay and subject to different conditions. The point I want to emphasise here is that it's maybe. So this as is the Act, is giving the Secretary of State a power to treat people differently, not necessarily a duty to do so. But the rules then go on to provide that for a Group 1 refugee, they will, as previously, be given refugee permission to stay, which has a minimum period of 5 years leave. Where they're a Group 2 refugee, they'll be granted what's now called temporary refugee permission to stay, which is for a period of 30 months, unless exceptional circumstances apply. I'll just note here, this is not in relation to Group 1 and Group 2 refugees, but at the same time as making the rules for Group 1 and Group 2 refugees, the immigration rules in relation to people granted humanitarian protection were changed so that people who are granted humanitarian protection are now also given temporary humanitarian permission to stay, which is essentially the same as Group 2 refugee status, and for a minimum period of 30 months. Dependents will be granted permission to stay normally with the same expiry date and the same conditions as that which is granted to the main asylum applicant. The explanatory notes to the Act indicated that temporary protection status will not include a defined route to settlement, but you can apply under the normal long residence rules, and would restrict family reunion rights and may only allow recourse to public funds in cases of destitution. So what has actually been enacted through the immigration rules? First of all, the good news, at the moment, there's nothing in the immigration rules which restricts Group 2 refugees' recourse to public funds. The government said all along that unaccompanied children would not be subject to an NRPF condition. The guidance indicates that the temporary refugee permission stay will normally include recourse to public funds, but that this may change at a later point. We understand that the Home Office is in discussions with local authorities before bringing in an NRPF condition, but the sort of temporary reprieve at the moment is that there is nothing in the immigration rules requiring NRPF to be imposed on temporary refugee permission to stay. Likewise, there's no restriction on employment or occupation, and the only restriction on study is the ATAS condition. So no restriction on employment and study, that's no change, no difference in treatment there between Group 1 and Group 2 refugees. The bigger big changes, I guess, apart from the length of the stay, are in relation to family reunion. So Group 1 refugees, the rules are unchanged. They're still entitled to family reunion with partners and children. Group 2 refugees have to meet the same requirements as Group 1 refugees and show that there are insurmountable obstacles to family reunion anywhere else. and that refusal of the application would breach the UK's obligations under Article 8 of the Human Rights Convention. So it seems as though this is mainly going to be targeted at people whose family are living not in their country of origin, but in another safe country. And then the question will arise whether the refugee who's here could in fact go and have family reunion with their family member in another country rather than the family being brought here. Those same requirements, the same additional requirements of insurmountable obstacles and breach of Article 8 are also added for family of people with humanitarian protection status. As I said, it's basically the same as Group 2 refugee status now. In addition, for some reason, there's an additional requirement in relation to humanitarian protection that the Home Office is satisfied that family reunion is in the child's best interests. So that's family reunion. In relation to settlement, only Group 1 refugees granted refugee permission to stay for 5 years are eligible for settlement under the settlement protection route. Those who've been given temporary refugee permission to stay are not eligible for settlement under any specific route under the rules, so they have to wait until they've accrued 10 years lawful residence and can apply for indefinitely to remain under the long residence rules. So this helpful table, which I give credit to Laura for, summarises the difference between the two groups in practice. So initial period of leave to enter is 5 years for Group 1 refugees, 30 months minimum period, save in exceptional circumstances for Group 2. It is renewable, and there is basically a safe return assessment supposed to take place as part of the renewal of the leave. Family reunion, again, it's the same as it's always been for Group 1 refugees. For Group 2 refugees, they have to show additionally that there are insurmountable obstacles to continuing family life elsewhere and would breach Article 8. In relation to settlement, for Group 1 refugees, this is after 5 years and with no language and life in the UK test. For Group 2, they have to get 10 years lawful residence and they will have to pass a language and life in the UK test. At the moment, they both have recourse to public funds and they both have unrestricted labour market access. So when does this apply? So these new rules apply to asylum claims made on or after the 28th of June 2022. The Home Office certainly interprets that as including fresh asylum claims, even if your client originally claimed asylum before the cutoff date. If they make further submissions on or after 28th of June, they could potentially be subject to differentiation. The transitional arrangements do, and this is in the policy again, make clear that people who tried to register their asylum claim before the 28th of June, but they were given the appointment to attend the ASU after that date, are considered to have made the claim before the commencement date, but only if they attended their scheduled appointment. And then there's quite a bit of further detail about what happens if they don't attend, whose fault is it, how much effort, how quickly do they try to rearrange it, in order to be protected by those transitional arrangements. If you've got a client in that position, again, it's important to look at the guidance. And then finally, how will this be applied? So the guidance states that what will happen is that once the Home Office has made a decision to grant refugee status, the caseworker will then consider whether the Group 1 criteria, coming directly, claiming without delay, and showing good cause for unlawful entry and presence are met. If they are met, then they will grant refugee permission to stay. If they are not met, then they will notify the refugee of a provisional Group 2 decision, including the grounds for it, and give them 10 working days to rebut. There's a really key part of the process at this point that your client should be given 10 working days to set out why they should be treated as a Group 1 refugee, not a Group 2 refugee. And that's something that we'll be talking more about what needs to go into that later. And there is legal aid available for that technical point. It's a separate matter start for responding to that. And at the moment it's paid at hourly rates. When a response is received by the Home Office, when they get your response, the provisional Group 2 decision, or if you don't respond within the 10 working days, they will then make a final decision on Group 1, Group 2 status. And just add that is how the policy says it will work. We have in practice seen cases where we've had a kind of Group 2 potential notification letter before a decision's been made on granting refugee status. It'd be interesting to hear what other people's experiences have been. So that is the end of my introductory overview to the statute, the rules, and the policy. I'm now going to hand over to Laura Dubinsky. Laura.
I need to ask Narissa to allow me to turn on my video. Great, I will do that now. Thank you. I'm hoping I'm visible to you.
You are.
Good, thank you. So I'm going to give a very brief tour of the legal context and some of the applicable legal principles for representations and legal challenges in differentiation cases. And as Alison said, later on, Michelle will be talking about the practical ways in which those representations and challenges can be made. Next slide, please. Thank you. So there are two kinds of decisions concerning which your clients may wish to make representations and challenges. First, the differentiation decision itself. It's decided that your client is a Group 2 refugee. Second, the treatment that flows from a differentiation decision, for example, a reduced period of leave. You may get those decisions at the same time in the same document, but it's important to bear in mind that they're not the same thing. So you may, for example, find for a particular client that you're not in a position to challenge the decision that they are a Group 2 refugee. But you may, on the contrary, have excellent grounds to challenge a decision to give them a reduced period of leave. In other words, don't assume that because your client is properly found to be a Group 2 refugee, the decisions over the consequences of differentiation are lawfully taken. So, and more broadly on this list, you may find that you wish to challenge the policy to which Alison has referred in some detail, and you may even, although I would urge caution over this, find that you wish to challenge the ECHR compatibility of the primary legislation. I'm going to turn now to context and legal principles, taking that context quite quickly before looking at potential grounds of challenge. Next slide, please. So the stated purpose of differentiation between Group 1 and Group 2 refugees in Section 12 is to deter asylum seekers from using routes that are not safe or legal, according to the explanatory notes. And we're going to look in a moment at some flaws in that justification. Next slide, please. So the stated justification does not have a proper basis in the Refugee Convention. There's no requirement to travel legally to claim refugee status. On the contrary, Article 31 of the Refugee Convention, to which Alison has already referred, protects refugees who have to resort to subterfuge in order to reach safety. And as the House of Lords recognised in Aspel, legal travel to a place of safety is, of course, impossible for many refugees. Second, there is no requirement in the Refugee Convention to claim asylum in the first safe country one reaches. On the contrary, there is an element of choice, as was recognised by the Divisional Court in the case of Ademi. Next slide, please. As many of you will know, safe legal routes are a chimera for many refugees, and again, that has been judicially acknowledged. Next slide, please. The other problem with the justification that has been offered by the government for differentiation is that Group 1 refugees will, of course, include people who receive better treatment, not because they use the legal route, not because their claims are any more meritorious than those of Group 2 refugees, but because owing to better funds or better resources, they were able to travel by air and thus directly on a visa and passport, even if those were fraudulently obtained. Next slide, please. Just highlighting some comments here that were made by the United Nations High Commissioner for Refugees, the agency mandated to supervise the proper interpretation and application of the Refugee Convention. UNHCR pointed out that the differentiation has no basis in the Refugee Convention, which has a single definition of refugees. Next slide, please. You may have noted in Alison's excellent whistle-stop tour of the legislation that Section 12(5) of the Nationality and Borders Act is not exhaustive. So when it describes the different treatment that can be meted out to Group 2 refugees, it does not give an exhaustive definition. And in this slide, UNHCR is referring to plans which have not yet been implemented, which would deny leave to enter or remain for even recognised Group 2 refugees and seek to remove those to safe third countries. And UNHCR points out that that would be a breach of Article 32 of the Refugee Convention, which closely circumscribes the circumstances in which a recognised refugee can be expelled. Next slide, please. Why else might one think that the differential treatment of refugees is contrary to fundamental principles of the Refugee Convention? Preamble of the Refugee Convention, setting out the objects and purposes of the Convention, refers to the right to enjoy fundamental rights and freedom without discrimination. Article 3 of the Refugee Convention prohibits discrimination between refugees, albeit on limited bases. And Article 34 of the Refugee Convention places an obligation upon contracting states to, as far as possible, facilitate assimilation and naturalization of refugees. Of course, the longer settlement route for Group 2 refugees is not consistent with that duty. Turning now, please, to the next slide. A key provision of the Refugee Convention in differentiation cases is Article 31. Section 12 of the Nationality and Borders Act borrows this language. And what Article 31 is a protective provision to shield refugees from penalisation from them for their mode of travel. But the purpose of making aspects of the Section 12 language mirror Article 31 is to attempt challenges that Group 2 refugees are being subjected to an unlawful penalty in breach of Article 31 of the Refugee Convention. Next slide, please. Be aware that although it's not in the convention itself, the Conference of Plenipotentiaries did recognise a duty to facilitate refugee family reunion for the signatory states. Now, in the next slide, if you could turn now to the next slide, I'm going to highlight some of the battle lines that are likely to feature in individual challenges to differentiation and to consequent decisions. I'm sorry that the writing may be quite small. First issue, has a person come directly? Now, here, the jurisprudence around Article 31 of the Refugee Convention, as well as some aspects of the Secretary of State's policy, are likely to be very helpful. What the jurisprudence clearly states is that given the humanitarian purpose of the Convention and of Article 31 itself, the term coming directly must be given a generous and flexible interpretation. The key issue is whether the refugee has stopped being in flight. Now, the jurisprudence on Article 31 of the Refugee Convention should, in my view, carry over when interpreting the terms in Section 12 and also in Section 37 of the Nationality and Borders Act. Section 37 refers to when a person has stopped, and the cases to which I've referred in this slide, Asfor, Kamal and Nathan, are helpful in giving a flexible, broad interpretation there. There is also the question in Section 37 of the 2022 Act, of whether the refugee could reasonably have been expected to claim asylum in the putative safe third country through which they travelled. Again, this jurisprudence is very helpful on that point. Next slide, please. Another issue to which you will be directing, no doubt, representations and challenges in differentiation cases where you're saying my client should not be treated as a Group 2 refugee is the question of whether they have presented themselves to the authority without delay. Alison has already pointed out by reference to the policy that there should be no mechanistic approach to this question. And again, this jurisprudence, Asfor in the House of Lords, Kamalanathan in the Court of Appeal, is very helpful. There's no single time limit by which a person must claim asylum. One must always look at the circumstances, for example, any particular vulnerability of the individual refugee. Next slide, please. Is there good cause for the individual's unlawful entry or presence? Now, this isn't really a battle line, or shouldn't be, because if a person is recognized as a refugee, they should be treated as having good cause for their unlawful entry or presence, as Article 31 of the Refugee Convention and the judgments in Asfor and Adimi make clear. Next slide, please. There may be general challenges to the policy. For example, the policy concerning duration of leave is a policy that permits deviation from a 30-month grant of leave only in the most exceptional circumstances, compatible with Article 8 ECHR. Is it also, in pure public law terms, an unlawful fetter on the Secretary of State's discretion as to the period of leave to grant, whether on the face of the policy or in practice? Those are questions that practitioners will no doubt be grappling with soon. Next slide. When dealing with individual decisions about whether to treat your client as a Group 2 refugee, and if they are Group 2 refugees, what consequences should flow, have regard, of course, to the classic public law grounds of challenge. For example, have relevant considerations been overlooked? Were your representations, for example, simply ignored? Has there been regard to irrelevant considerations, for example, erroneous understandings of the facts of your client's case? Has there been a fettering of discretion in your client's case, i.e., did the Secretary of State, for example, if deciding to grant your client only 30 months leave, did she consider her discretion to grant a longer period of leave? Next slide, please. Article 8. Both the private law and family life aspects of Article 8 of the European Convention of Human Rights will potentially be in play where a person is deemed a Group 2 refugee, with consequences for their access to family reunion and for their ability to put down roots and develop a stable new life in their country of refuge. Article 8 may go to the differentiation decision itself, your client is a Group 2 refugee, or to the decisions about consequences, duration of leave, family reunion, or both. And I know that Michelle is going to be devoting more attention to that, so I'll turn to the next slide now. Article 14 of the European Convention of Human Rights prohibits discrimination in the enjoyment of rights and freedoms in the Convention, including on grounds of other status. You don't have to establish, if you're invoking Article 14 with, for example, Article 8, but there is actually a breach of Article 8. What you need to establish is that it's in the ambit of another convention right. As we just saw a moment ago, a decision to treat a person less favorably as a Group 2 refugee undoubtedly does, in my view, fall in the ambit of Article 8 ECHR for these purposes. And there should be no difficulty in establishing that Group 1 or Group 2 is a status for the purposes of the last phrase in Article 14. It is another status. The real question here in Article 4, if you do bring an Article 14 challenge, is likely to be justification. If I could just ask for the next slide, please. So this is the classic formulation in Bank Mellett. How should justification be approached? Is the objective sufficiently important to justify the limitation of a fundamental right? Is it rationally connected to the objective? Was a less intrusive measure available? And having regard to these matters and to the severity of consequences, has a fair balance been struck between the rights of the individual and the interests of the community? Next slide, please. I have highlighted the possibility of Article 14 and 8 challenges, but I would stress that there are questions that practitioners should ask themselves. First of all, tactical questions. Any discrimination challenge here to differentiation would need to be very carefully thought through. There is a risk that a discrimination challenge where the privileged group does not have their entitlements set in stone results in leveling down, not leveling up, i.e. be very careful in any challenge that you don't end up with a leveling down of group 1 rights rather than leveling up of group 2 rights. And I've also stressed appropriate target. A broad brush discrimination challenge to the overall scheme, if it is very risky, because if it fails, it may dent the ability of particularly vulnerable groups or groups with legally recognized needs, for example, the mentally ill, those lacking mental capacity, unaccompanied asylum-seeking children or families with children. It may dent their ability to succeed. And my view certainly is that if people are contemplating Article 14 challenges, it is advisable to start with the most attractive challenges or more limited bases and work up rather than going straight for the jugular and seeking a declaration of legislative incompatibility. The other points there, I think I will leave you to go away and think about, because they are really on the detail of Article 14 challenges. But I think that the takeaway message here is that despite the great difficulty that this legislation and the policy and rules pose, there are many available challenges, both for individuals and on broader basis. And I'll turn over to Michelle now for the detail of how those can be brought.
Hi, everyone. Thanks very much. I hope you can all hear me and see me. If you could go to the next slide, please. So just to outline what I'm going to be focusing on, I'm really going to be talking about the practical steps in responding to Minded 2 letters, also just to preparing yourself for the fact that you may have to do that down the line, and the tactics of when you start addressing Group 2 in individual cases. And all of that is in mind to the fact that you may end up having to bring an individual challenge to a decision. And those challenges are most likely to be successful when the right sort of evidence has been put forward and when you have made the right sort of representations in the lead up to needing to bring that challenge. I won't be talking about systemic challenges, not least because of the views as Laura mentioned, and as certainly Alison and I have discussed at length in us looking into this issue together. Bringing systemic challenges to the scheme probably has a lot of risks at the moment, and really the focus for now is probably best on individual decisions and trying to make some headway there. It may be that in due course, if there are patterns of decision making or certain types of cases that have to routinely be challenged, for example, putting traumatized people on limited leave forms on the temporary refugee protection route that is interfering with their treatment. That may be an area, for example, that ends up being something where a systemic challenge could be brought. But for now, really the focus, I think, should be on individual cases. So you've already heard about the decision-making process in Alison's talk. I'm going to jump through that very quickly, just to set what I'm going to discuss in context. You have links there and the names of the two key policies. A lot of the points I'll make will be derived from those policies. It's really the whole of the permission to stay policy that's relevant, and then it's page 66 onwards of the assessing credibility policy. And as Alison said, I'd really encourage those to be looked at carefully, really for anyone doing this sort of work, and not just when you get the rebuttal letter, but right at the beginning of when you're starting to represent people in their asylum claim. Now, the process of deciding whether you're a Group 1 or Group 2 refugee is supposed to only decide at the point that you are recognised as a refugee, although, as Alison pointed out, it's possible that the Home Office may be looking at this at an earlier stage. There are two decisions that need to be made within that process. The first is whether you're a Group 1 or a Group 2 refugee, and the second is if you're a Group 2 refugee, are there exceptional reasons why you should be granted a longer period of leave? And if so, what length? 5 years, like normal refugee protection, or ILR. So keep in mind, there are different options for that longer periods of leave that you and the Home Office should be considering. If you could go to the next slide. The standard of proof, as the policy makes clear, is the balance of probabilities. And the policy also says that decision makers should use documents such as a screening interview, substantive interviews, and any other information, for example, case notes or preliminary information questionnaires, to decide whether a person is a Group 1 or Group 2 refugee. Now, that obviously any other information also will include information that you put forward as the representative. The decision making must consider whether the refugee had the freedom to claim asylum and knowledge of the asylum system, as well as their personal circumstances, including their age, a range of different vulnerability and situational factors, and when considering whether they came directly, and on considering whether they delayed. And Alison has already talked about a lot of the factors that will be relevant. Now, the next slide, please. The policy does specify that in minors' cases, it should be considered less likely that they could reasonably have taken actions to claim asylum in a safe third country or without delay in the UK. So this is really important. The policy is quite helpful on minors' cases, and really it's only if there's evidence that they were aware that they should have claimed elsewhere and chose not to, that they're automatically excluded from temporary refugee protection, that they're not automatically excluded. So this is really important. The policy talks about things like, if you have a child in a family group, it probably is not their decision not to claim en route. That might be their parents' decision, and they shouldn't be punished for that. So if you have a family and each person in that family is claiming asylum, then you may end up, for example, with the parents or even one parent being who made all the decisions, being the Group 2 refugees, and arguments that the other applicants, and particularly the children, shouldn't be given that status because they were not the ones making decisions. Even when a child is travelling alone, they may be acting on advice either of family or agents. And where they're a child, the policy insinuates that it's not expected that they will challenge any advice in the way an adult might be expected to make their own decisions and to know that they could claim asylum somewhere else. Whereas if a family member says, you know, we're sending you to the UK where your uncle is, or for whatever reason, then the child is, if the child just goes along with that, then they should not be made a Group 2 refugee. Now, there's also specific guidance on trafficking victims. It's pretty vague, though. It says trafficking victims with a positive conclusive grounds decision related to their asylum claim should generally not receive temporary refugee permission. But this is assessed on a case-by-case basis. And also that an outstanding referral to the NRM may also be grounds for not granting temporary refugee protection. So obviously you want to be relying on that in trafficking cases. I would say you still want to address the broader factors in trafficking cases that you would address in other cases, but you can certainly say that there is a presumption that they don't get temporary refugee protection if their trafficking is connected to their asylum claim, or if they're in the NRM for that type of trafficking to be considered. Next slide, please. Now, the policies also include the following in relation to duration of leave. First of all, as Alison's already explained, the policy says that longer leave will only be granted in the most exceptional circumstances. That's also the need for exceptional circumstances is also referenced in the rules. And that is said to mean a situation that is distinguished to a high degree from other cases. The policy also says that the decision maker must consider a child's best interests in deciding whether to grant a longer duration of leave, and that there may be exceptional reasons for children to get a longer grant of leave. But it also says in the vast majority of cases, temporary protection will be sufficient, and that it's very unlikely that best interest considerations will override the wider policy intention. Now, here you see the very different approach once you're within Group 2 to getting a longer period of leave taken to children than the initial decision, which is whether or not they should even be in Group 2. So it's going to be much easier, simply by virtue of being a child, to not be put in the Group 2 category in the first place than it is going to be to argue for a longer period of leave. And that's why when you're looking at this, it's quite important to look at those two types of decisions separately. The factors that will be relevant are really very different, even though there may be some overlap in looking at particular characteristics. Even those characteristics will be relevant for different reasons. Now, the policy also makes clear, and of course this is always the case, that you can request longer leave either as part of an initial claim or at any point thereafter. And this makes no sense what I've actually written, but it says it's meant to say that the policy also indicates that where there are particular vulnerabilities indicated in an asylum claim, then this should be considered when deciding whether to grant longer leave, even if no specific request is made. Now, that could tie into a fettering of discretion type challenge, for example, especially if, say, you took on a case quite late in the day, but once the decision had been made, if in fact there were factors raised in the claim that really should have made the decision maker think about whether or not to grant longer leave, and they didn't do that, then you'd have a challenge based on fettering of discretion, failure to give reasons on a normal public law challenge. Now, in my experience of doing, I do a lot of challenges to 10-year route to settlement cases and failures to grant longer periods of leave. It's very common anyway, even where you request longer leave, that you just get the standard decision with the 30 months leave in Article 8 cases or family life cases, or there's a real potential, and we haven't really seen this in practice yet, but there's a real potential, I think, for you just to get a temporary refugee protection 30 months decision once you're a group 2 with no reasons why you're not getting longer leave, even where you've made reps on that. And if that happens, then obviously that can be challenged in a similar way as I just described. So the next slide, please. The minded to process, as Alison explained, there's no right of appeal or administrative review, but there is therefore this minded to opportunity to rebut the finding that you're a group 2 refugee. And that is a 10 working day period. It is important though that the policy says it's extendable, and there is specific guidance in the policy on asking for extension. So if, for example, you need to get medical evidence or other evidence that's going to take you some time to get, then you should explain that and make extensions where needed. The criteria are really detailed. There's, for example, for duration of leave, the policy, as I'm going to come to specifically, says that if you're relying on medical reasons, you need evidence. So if you therefore need time to get that evidence, then do make the appropriate extension requests and use what's said in the policy to do that. The next slide, please. Now, the practice tips. First of all, there are obvious preventative steps we can take as practitioners to stop people getting into the scenario where they may be considered a group 2 refugee. So, for example, it's really important now to ensure that asylum claims are lodged without delay after instruction. And that is something, certainly, many years ago when I was a caseworker, often we used to delay lodging an asylum claim while we gathered evidence. Now that's obviously really dangerous and a really bad idea. It's probably unnecessary now anyway, given all the delays with actually progressing asylum claims. So it's really important, particularly where there's been any prior delay, that the minute they get access to a lawyer, you make sure to lodge that claim quickly. And by lodging that claim, that's just really calling up and requesting the screening interview, as Alison explained. And that's obviously the same way you take on a client for a fresh claim. It's going to be really important probably to get that in quickly. Again, we would delay for a really long time while gathering evidence, and this system may affect how you go about that, whether you lodge something and then say, I'm going to follow this up with evidence, but I wanted to lodge it without delay. So that's something to really keep in mind. It's also important where you are assisting clients to enter lawfully, say, for example, for family reunion purposes. So again, I do a lot of cases where we are doing outside the rules family reunion applications, and having someone, maybe there's a minor or a young adult here who's been recognised as a refugee, and the rest of their family is, in a refugee camp in Ethiopia or waiting in Pakistan, and they apply, they are granted leave to enter outside the rules, but they're only going to be on, an Article 8, 30 months leave to remain, 10-year route to settlement with paid applications. So it's really important when they are in fact refugees themselves to claim asylum on arrival. And again, they're coming through the airport. So they either may be expected to do it at the airport or very quickly thereafter. And normally you'd want to give them a letter or something that they can present to say that they want to claim asylum, or write to the Home Office the day that they're arriving. There can be reasons, risks of leave being cancelled, or accommodation issues arising, etc., why you want to write rather than get the family to claim asylum, or they may just not be able to communicate. But these are all things to be thinking about, and that you have to think about differently because of this policy. It's also going to be really important to clarify relevant matters in screening or substantive interviews where there's a risk that something a client said means they could fall into group 2 status. So, in a screening interview, a client is often asked why they didn't claim asylum somewhere else. And quite often they may just say, well, because I wanted to come to the UK. and not explain, for example, that they were actually under the control of an agent all the way through the journey, or something else that is important, because of the way the question is phrased. It may not come out, but it may be very important in terms of excluding them from a risk of group 2 status. So do think about that when you are responding to screening and substantive interviews. Now, that's not to say you necessarily want to address group 2 status directly. You may not want to. It's a real tactical balance between addressing relevant matters in evidence, or when you're writing in with corrections, and actually saying this is relevant because it means they're not a group 2 refugee. You may, in a case that is very borderline, not want to mention it at all, for example, because you don't want to start putting ideas into the Home Office's head. But obviously there's a difference between directly mentioning it and making sure that evidence that's helpful to your client on this issue comes out through the process, so that it's not a matter of you down the line, you know, a year later when a decision is made, saying, oh, actually what he said in the screening interview was incomplete, we just didn't say anything at the time. And the other reason why I think it's really important to make sure you address matters and take instructions on all things relevant to group 2 status at the beginning, when you're first instructed, and if that's at the beginning of the claim, then at that time, is because people might forget. I mean, there's going to be really long delays probably in deciding their asylum claim, and so asking them details much later down the line is quite risky. So be ready to address all the issues, and when I say be ready to address, that's because, again, I'm not saying necessarily make representations on all these things, but really it's making sure you've got those instructions in the bag. So there are reasons for the UK, there are reasons why they went through a third country, the lack of safe routes, the fact that they didn't have the money or the ability to get a visa or to take a plane directly, that visit visas just aren't granted. You may want to look at that. You know, the Home Office suddenly stops granting visit visas, don't they, as soon as a war breaks out in Syria, whereas previously they may have given Syrians visit visas. So things like that, a lack of knowledge of UK policy, that asylum claims should be made in the first safe country. Obviously that's not a requirement of the Refugee Convention, so they may not have even known that they should have claimed asylum somewhere else. The amount of time they spent in third countries, as the guidance makes clear, if they just spent a few hours, they probably shouldn't be deemed to not have come directly. Whereas if they spent weeks, according to the policy, they are likely to be deemed to have not come directly. However, the case of Ademi would suggest that even quite a long delay is actually means that someone could still have come directly if, for example, they were just trying to find a way to get to the UK. So the fact that you can't, you can travel from Germany to France, no problem, but then you come up against border control in the UK and you can't continue your journey. So under the definition of coming directly in the Refugee Convention, and that has been confirmed in our jurisprudence, that would not necessarily exclude you. So again, you want to be looking at the policy, but you also want to be looking at the broader law to see what points you should make and to make sure you've taken instructions on relevant matters. You look at control during the journey. Did they have, were they in a lorry the whole time? Was were they under the control of an agent? Did they know where they were? Did they really have an opportunity to claim asylum? Again, this sort of example is covered in the policy. The safety of third countries and the effectiveness of the asylum system. So there's examples given. If if it's a claim based on sexuality and there is serious discrimination against whatever group you would fall into in a country that you pass through, then even if it may otherwise be safe, you can't be expected yourself to claim asylum there. the reasons for your delay in claiming, maybe access to legal advice, etc. And for surplus claims, when you realised you need to claim asylum, again, the policy recognises that just because the Taliban takes over Afghanistan on X date doesn't mean you knew immediately that there was a need to claim asylum. Maybe maybe they were going to be overthrown again a week later. Often these kind of big changes are not just dramatic and black and white, and people may hope that things will change, and it's only when it beds down that they realise, actually, I've got to claim asylum here. So all of those type of issues you should have instructions on and be ready to make reps if and when it's a good idea to do so. And also, when you're instructing experts during your asylum claim, think about these things. Is there anything that they should be dealing with, particularly if age, or if you have social workers reports, for example, or vulnerabilities may explain failures to claim asylum in another safe country, or the delay. Next slide, please. So as we've already said, policy's got lots of great examples in there. Also, though, don't be restricted by them. Don't assume they're right. I've already discussed the tactics of when to make representations. I think that that's really going to be a case-by-case decision. We have to see how Home Office practice evolves, what sort of cases they tend to pursue a Group 2 status and what they don't, and whether, in your case, Group 2 status is such an obvious risk. Now, obviously, someone who gets dropped out of an inadmissibility process because it can't be removed anywhere, for example, you're going to have a really high risk, and it may be something you just address at the outset. But for other people, where it's a delay and they may not raise it at all, you might just want to stay quiet until you get that minded to letter, but armed with all your instructions. And so no matter what, though, do ensure the evidence you put in deals with relevant matters, particularly where you're at risk, if it doesn't, that you get accused later of not having said that before, and therefore it not being believed. And as already discussed, victims of trafficking may not get temporary refugee protection. So where, even though for whatever reasons in your individual case you may otherwise have decided not to refer into the NRM, or your client may have not given consent for that, there may be a reason to do so if you get a Group 2 indication. Next slide, please. So as already said, you can make the request for duration of leave at any time. If there's a reason, then you should, with your asylum reps, you should ask for ILR. If, for example, you've got medical evidence that in order to access treatment from PTSD, you need a sense of stability that even refugee leaves, normal 5 years, won't bring. You may just want to make sure an expert addresses that broadly, that they need a stable form of leave, i.e. settlement, and then you can request that at the outset, as you might do already before this whole differentiation policy came in. But you could also raise it at the time you're seeking to rebut the Group 2 minded to. Obviously, at that point, you're at risk of an even shorter period of leave. So it may become relevant then, when you didn't think it was so relevant before, and you didn't want to raise it before because you didn't want to suggest that Group 2 status was on the cards for your client. So think about the point where you want to raise it. It's very important, as we've said, that you get the right evidence to show the impact of precarious status in view of your client's particular characteristics, so mental health, disability, age. I mean, I have a case now of a client with a learning disability who simply can't handle all the forms, and he's been put on a 10-year route to settlement, and we're arguing that it's not appropriate because he simply can't cope with the process that entails. Obviously, you have frequent safe return reviews. For someone who has a history of severe past persecution and consequent trauma, it may be highly inappropriate to put them through a safe return review every 30 months. Again, for children, it may just not be possible for them to fill out the forms themselves if they're a younger child, if they're unaccompanied, or there may be other reasons why it is disruptive to them and their best interests. And again, you might have a social worker or someone who can comment on that, or the parents. Always, make sure you're thinking of that best interest assessment, and remember that the policy does say that specific evidence must be provided where there are medical or mental health issues, and you want to say that because of that a longer period is necessary. Next slide, please. There's a lot of evidence about the harm that the 10-year route has caused, and that's really looking at the 10-year route for private life cases and Appendix FM exceptional family life cases. But do remember that that 10-year route is a bit different, because at the moment here we have no recourse to public funds, and presumably, as I understand it, there aren't fees that have been introduced for these renewal applications. I hope someone corrects me if I'm wrong about that. A lot of the evidence of harm is caused by the high level of fees and the imposition or the threat of the imposition of the NRPF condition. So just be a bit careful when you're using that evidence. It's not that it's not useful, but it is important to acknowledge the differences and to explain why, it still shows that this type of 10-year route to settlement is also harmful. And one of the key reasons it will be is that it undermines integration. And there is a lot of evidence about that. There's a great We Belong report about the 10-year route undermining integration. Again, it's in a different context, but it will give you lots of ideas. And as Laura has already said, this is relevant to Article 34 of the Refugee Convention. And the UN has said that a system designed to maintain a refugee in a precarious state intentionally frustrates rather than facilitates their integration and naturalization. So these are arguments that can definitely be used, and particularly in conjunction with reasons why your client specifically is going to suffer on a precarious route. Next slide, please. Yeah, so keep in mind when you're evidencing that challenges will be judicial reviews based on either Article 8 or 14 or of the ECHR or public law grounds, as Laura's already discussed. Now, that means you want evidence to be there before the decision maker. It's much easier to bring a successful public law challenge where all the evidence was already in. So hence why you want to be ready to make these arguments by gathering relevant evidence during the life of the asylum claim, and also requesting extensions so that you get the evidence in before the decision. I think strong evidence, obviously, as in any of these types of cases, will often be the key to success. But if you do miss something, or there is further evidence that you realise is important as a result of the reasons in the decision, then do try and get that in at PAP stage, because often in these types of cases, you can say, you'll be saying at PAP stage, please reverse your decision. And obviously that is an opportunity to reconsider, and giving further evidence then could prompt an agreement to make a new decision and have that considered. And even if you then get a refusal, you'll then get a decision that takes everything into account, or maybe doesn't properly, but at least they had it there. So you can rely on the fact that they had it, but they didn't properly address it, etc. And also remember that very worst case scenario, where there's a human rights judicial review, there's not necessarily a barrier to post-decision evidence, because the court does need to decide for itself whether the decision breaches human rights. And there is case law on the fact that they may take into account post-decision evidence in doing so. That's the reported case of BAA and TAA in the upper tribunal. That's in the context of the Dublin JR. So the next slide, please. So just lastly, tips on family. it's really important that the legal provisions say that those who are that family members who are refugees themselves cannot be treated differently. So it may mean that you know, the family members who are dependents and either joining for family reunion or coming with the lead applicant who perhaps was responsible for the decisions of what happened en route, that they should be claiming asylum in their own right. So always think about this: if a family member might get caught by differentiation otherwise, that's also people who come in on family reunion visas. If their leave is similarly restricted as it would otherwise be to the leave of their of the main applicant because they're a dependent, but in fact they're also a refugee, then they're going to need to claim themselves now, even though previously they wouldn't have needed to. It's quite unclear whether the family reunion restrictions will in practice have an impact, because obviously the type of cases that the narrow categories of cases that come under the rules really do reflect those that should anyway be protected under Article 8. But do be wary of the narrow definition of family life in the policy. Minor, you know, a lot of the law on adult relatives and the need for particular dependency gets transplanted where you've got minors, so either a child and an adult sibling or minor siblings, for example, and there are strong arguments that children will still maintain their family life ties with, say, adult siblings, or certainly with other minor siblings, even if they live separately for whatever reason. There's actually some quite helpful Supreme Court family law cases on that. Now, also though, do keep in mind still that because of the potential that there will be a need to make more, you know, a more individualized Article 8 argument as to why you should get family reunion, that again, you want to have that in mind when you're preparing the evidence for the asylum claim. So, you know, not forgetting to talk about who their family is, which obviously we should always do with family reunion in mind, but also talking about the relationships, the fact that they only separated because the person had to leave because of claiming asylum, and just making sure that those points are, you've got a mind to this when you're preparing the asylum claim. And I think that is everything. So now we can move to questions. Alison, I'll let you take over again.
Thanks very much, Michelle and Laura. That was extremely comprehensive and good. And I think apart from anything else, this really illustrates that we need to all be thinking really actively about this from the start and getting very detailed instructions. So we've had a couple of questions, but if people do have more questions, please do pop them into the Q&A on any aspect of what we've been talking about in terms of differentiation, whether it's the final points of the law or the practice or the procedure that you have questions about how to go ahead at this point. So the first question we've got is, if your client has passed through more than one safe country to reach the UK, presumably you will then need to address the obstacles that prevented an asylum claim in each respective country. So my simple answer to that question is yes, you will. And then I'm going to let Laura give a slightly less simple answer.
I don't know if I can be seen and heard now.
Yes.
Great. Again, yes. But I would break it down a little by looking at section 37 of the 22 Act, which defines coming directly, and which will apply to the question of coming directly in section 12. So there's two aspects of it. First of all, did the person stop? And I'd remind you there of the jurisprudence that I mentioned in my piece. So, for example, Kamal and Asfor, the key question is whether the flight has stopped. Has the individual remained in flight? So if a person stops for weeks in the course of arranging onward travel, you would say that's actually not a stop for these purposes. Stop has to be interpreted compatibly with that jurisprudence. The other point in section 37, of course, is the one that you're highlighting, Sarah, is could the individual reasonably have been expected to claim asylum in that country? And that's where you will also be talking about issues of control, of knowledge, of practical feasibility. But I would say, don't concede that they stopped unless you have to. So, you know, think in those two limbs of section 37, did the individual stop or were they still in flight towards the United Kingdom? And then put your argument, if you can, in the alternative, even if they did stop, they could not reasonably have been expected to claim asylum for the following reasons.
Thanks very much, Laura. I just shared my slide of section 37 while you were talking, so in case it was helpful. Yeah, brilliant. Thank you. Michelle, did you want to add anything on that?
Sorry, Alison. I was messaging Alison saying, stop sharing your slides. I didn't realise it was actually relevant because it was covered by, yeah. Anyway, no, not to that one, no.
Great, thank you. So the next question we've got is this. So the test of coming directly to the UK has a lot of overlap with the inadmissibility test for connection to a safe third state. To what extent should we therefore be fighting inadmissibility decisions, even where the Secretary of State still agrees to consider a case which has been treated as inadmissible, i.e. because of exceptional circumstances or it's not possible to remove in a reasonable period, given the implications of such an inadmissibility decision on the refugee group decision? Is it worth considering JR for a decision to treat a case as inadmissible, even if the Secretary of State also accepts the claim will still be considered in the UK? Michelle, I think you're going to answer that one.
Yes, I think that's a great question, actually, and it is really important. It's important to remember that these are actually the same tests, not least because the inadmissibility guidance has literally been morphed in support clearly of Rwanda to remove all of the examples. So we keep saying, look at the policy, there's all these helpful examples. Now, the inadmissibility policy has gradually been stripped of all of those examples. But these policies that we've talked about is addressing exactly the same question and can and should be used at that earlier stage when you're trying to get your client's claim admitted. Now, yeah, I think it's really difficult. I don't think there's not a definite right and wrong answer. To me, I would probably be looking at, this point is really that the decision on whether or not your claim was inadmissible because, for example, the Secretary of State considered that you didn't come directly, that has been decided against you. But because it took too long, or they've met their Rwanda quota, or hopefully that will never happen, but whatever it is, there's no way to actually remove you. The question is, it's still material that they've made that decision against you, not least because the Group 2 guidance says if you were inadmissible, then you should, you're probably going to be a Group 2. That's the type of category that you'll almost certainly be Group 2. So that decision is still got relevance to you down the line, the fact that it's been made against you, even though it's no longer of immediate relevance to whether or not you whether or not your asylum claim is going to be considered here. I think that there are certainly arguments that you can, JR. You have to be ready to explain to a court why the decision is still material, why the JR hasn't become academic, and I've just given the reason. So technically, yes, I think you could pursue a challenge. Whether tactically you want to is another question, and might depend on how black and white and how strong your evidence is at that point. Obviously, if you run that challenge then and you lose it then, you may have more difficulty down the line. In circumstances where you might have much better evidence down the line, but the fact that you've had an earlier failed challenge, even though you could potentially bring a second one because of new evidence, it could tactically be, you know, not a good idea. So I think, you know, it's not a question, it's definitely something to think about in your individual case. And perhaps if you had such strong grounds, you know, you were literally in a lorry the whole time, there was absolutely no evidence to suggest otherwise, and the Secretary of State had just made, which we've seen, I think, in some cases, just made an invisibility decision because you know, because of how you entered or where they found you, then, you know, then you may want to consider it. But I would probably be a bit cautious. I don't think you'd have, I doubt you would have a problem down the line bringing a challenge, because you would say, well, it's obviously of renewed relevance now. We didn't even know that we would, you know, we would be in this group 2 category until now. We didn't have that decision until now. So I don't think you'd be prevented from challenging it later. But it is, you know, it's a really good point.
Thanks, Michelle. So I'll go on to the next question we've got, which is somebody's asking, can I ask what happens when a child submits an application as a child but turns an adult at the time of the interview? Can this impact on differential treatment? I'm happy. Michelle, do you want to answer that, or I've got a thought?
Go for it.
I mean, I would have thought, because in terms of the differentiation, which is based on your behaviour prior to the submission of your asylum claim, you would be treated as a child for these purposes because you were a child when you, in the time of the conduct, which is kind of blameworthy in the sense of leading to you being treated as a group 2 refugee. So it should be approached on the basis that you were a child, and so may have been less able to make your own decisions about when and where and how to claim. Michelle, anything to add?
No, that's what I was going to say. I think it's really going to be, I mean, the policy, I haven't actually checked whether, you know, what exactly the exact wording of the policy is, but normally the question of whether you're an unaccompanied child asylum seeker is about when you lodged your claim. So certainly, as Alison said, and whatever the policy said, there'd be very strong arguments that all that matters is, you know, your age at the time of that behaviour.
I would also, sorry, if I can also chip in. I mean, you may also have a situation where a child turns 18 during transit, but the fact that the individual was a child during some of the conduct is going to be important. And of course, it's not a hard-edged thing that you turn 18 and suddenly become more able to control your life. So you, I think, would want to make submissions about vulnerability control. And I would also just highlight, purely by analogy, that the Grand Chamber in Maslow in Austria, for example, accepts that the best interest of a child relates to conduct of a child, even where the immigration decision is taken vis-a-vis an adult. And so you might say it's not consistent with the best interest of a child to penalise the adult for actions taken as a child. Anyway, a thought there about an analogy that might usefully be drawn.
Yeah, really helpful. Thank you, Laura. Got 5 minutes left. I'm just going to move to one more question, and then I'm going to give a very short answer to the last one as well. On the next one is interesting. Would a fresh claim on entirely new factual matters, i.e. religious conversion, be treated as a sur place claim, or can behaviour prior to the 22 Act, which has already been assessed by the Secretary of State in the initial asylum decision, be relied on in the differentiation decision? Guidance isn't particularly helpful in commenting on this. I think the whole, I'm going to say a couple of things and then see if Michelle wants and Laura want to add. The whole relationship of fresh claims to this test is kind of interesting and needs to be tested because, well, first of all, does the statutory language in the transitional provisions that you made an asylum claim on or after 28th of June 2022 apply to fresh claims? The Secretary of State thinks it does. But secondly, is there a difference, as you identified, between claims based on entirely new factual matters and those based on the same factual matters but new evidence? And here you're talking about a fresh claim based on a religious conversion. Let's assume the religious conversion happened after the 28th of June 2022, and your previous claim was on political opinion, say, then I would argue that you should be treated as a surplus claim, and therefore the only real question is, did you claim without delay after your conversion, or after you appreciated that your conversion could give rise to a claim for refugee status? And what were you doing in between? Did you stay here unlawfully after your previous claim had been refused and before you converted? And did you have good cause for that? I think will come into consideration there. Michelle, Laura, anything to add to that one?
Well, just to say, if you got leave in the end, if you got any form of leave, I think that was pointed out, I'm sure by Alison, I don't, but you don't, if you're making a surplus claim and you had leave at the time the grounds arose, you don't have to claim asylum before your leave expires, but you have to do it before your leave expires. So you won't come under these provisions if it arose during a time when you had leave. So that's just another point, but I don't have anything more to add.
All right. Thank you. And just very quickly on the last point, I think the thing I was just going to mention there is the family asylum claims policy, which I'm going to pop a link to, but I think that that's going to be relevant there, which requires the Home Office these days to treat children as, you know, to give children the opportunity to raise their own asylum claims. And the policy, yeah, Michelle, anything to add on the way that the policy deals with dependents who aren't?
Yes, I think there's two questions that are related. I mean, yes, certainly children will be making claims in their own right more often. You still have to make sure they have a claim, and that, you know, there is, it depends on that. If they're, you know, from Syria or Eritrea, then probably, and they left illegally from Eritrea, then they will probably. But if it's really because the father was involved in politics and he's taken the family with him or something like that, then the child just may not have any claim. So you do have to obviously look at it to see whether there is a claim. But yes, where there is a claim, you want to be lodging that independently if the child would be group 1, whereas the other family members, the person who they're dependent on, might fall under group 2. And you probably want to do that from the beginning rather than have to start, or, you know, much later. Although it's not the end of the world if you've got to start later, because they will have that 30 months leave. So, you know, you will, it's not like they'll be liable to removal. And yes, it does apply to UASCs, but as I said, the policy makes clear that it's quite unlikely that they should be made a group 2 refugee. So even though it technically applies to them, they're likely to have an excuse either for delay or for not claiming asylum en route, unless they really should have, unless there's something sort of positive to suggest they should have known to do otherwise. And Maslov was, oh, you've answered it, it was felt right. Even that, yeah.
Fabulous. Look at that, 2:30. We've answered all the questions and covered all of differentiation in lots of detail. I hope it's been really useful for everyone. Thank you so much to Michelle and Laura, and thank you for everyone who asked brilliant questions and for coming along.
Yes, and thank you to Alison.
Thank you.
Thank you, Alison, absolutely.